Most of you have received Rico's recent bulletin on lockboxes, where Rico explains that the seller should understand the implications of putting on a lockbox at their property. Now, in light of that, I've received multiple phone calls where realtors are actually panicking now, and they're asking me, well, where does it stop? Where do we draw the line in terms of getting instructions in writing? As far as we are concerned, the standard today, and Rico's made this abundantly clear through various cases, is that there should always be informed consent. Now, what this means is that it's not enough for you to explain to a client something. You have to go a step further and get it in writing. So recent cases that we've seen, which I've discussed at length, include situations where contracts are signed in the backseat of a car, and Rico's made it abundantly clear that such contracts may not be enforceable because the client doesn't actually understand the implications of their actions. They don't have informed consent. And so this bulletin, when you read it, you should be able to understand the fact that anytime you're doing anything that may affect the client, you have to have the clients acknowledge the implications of those actions in writing. And so as a part of your listing agreements, you have the option of adding in a schedule. Always put in a schedule where you write in everything that you have to disclose to the client. I know some of you might be thinking, well, there's already an indemnity which protects me and my company from any loss or damage that may arise as long as I'm not negligent in conducting the sale of the property. But above and beyond that, it is always a good idea, and in fact, based on what we're seeing now, it's almost advisable that you go as far as inserting these provisions into the actual listing agreement or the buyer representation agreement, where you're reiterating your commissions, get initials next to the holdover period. And I've actually suggested in some situations where clients go as far as having the client pick up an actual pen and in their own writing write in the provision that the salesperson wants them to write in, and acknowledge that, sign off on it and initial off on it. So then that way it becomes very difficult for an individual to then turn around and say, I didn't understand the consequences of my actions. So again, that's the whole basis of informed consent. Now, the next thing that's really important to understand is that when it comes to everything we do, a lot of clients are calling me, well, Ricky, market's a little bit slower, but some clients are still, facing bidding wars, and they're going way higher than I would recommend in my professional capacity, or opinion rather, in terms of making an offer price. So in this specific situation, I always advise two things. There is an OREA form where if the individual client is not inserting any conditions, you can actually write into that form the implications of not making the offer conditional on, say, inspection or financing. Further to that, you always want a written paper trail where you've explained to the client the implications of the actions. Now, you might have some client who comes to you and says, listen, I know the property's worth $500,000. I don't care. I have $700,000. That's what I want to spend on it. In such a situation, you are required to follow the client's instructions. The key thing to remember here is have them acknowledge in writing the implications of their actions. Okay? And so as far as your representation agreements are concerned, have initials made right next to those provisions so your client can't then turn around and say, I didn't understand what I'm doing. Sign contracts in a professional environment. Do not sign contracts at a bar where there's liquor and there's a possibility of the client to then turn around and say that they were intoxicated. They didn't understand the consequences of their actions. So be very careful, be very mindful. The standard is quite high. It's not enough for a registrant to now say, oh, I didn't, I explained this to the client. We know that as far as the agreement of purchase and sale is concerned, there's an entire agreement clause which says that whatever's in the agreement is the understanding. And so based on that, it's not illogical to understand that as a professional, you should be taking all instructions in writing. As a lawyer, that's my standard. I take every instruction in writing. Sometimes I have to go as far as sending a client to another lawyer where they get a certificate of independent legal advice because I need to be able to protect myself if something goes wrong tomorrow. Now, I'm not suggesting that that's the same standard that is applicable to registrants. However, it's very, very, very critical, especially in today's day and age, that you guys educate yourself and that you guys make sure you've covered all of your grounds. Talk to your broker of record, talk to me in my capacity as a lawyer. I'm more than happy to assist you through these sorts of issues. I hope this video helps. We'll see you again next time.